First of all, thank you everyone for joining today. My name is Fiona McClellan and I'm a director in the employment team. And I've got my colleagues Madeline Joseph, who is a solicitor in the team, and Cara Lowe, who is a senior solicitor in the team. And they are both also on the webinar today. Oh, I think there's some background noise, so if everyone could just go and mute, that would be great. The session today will cover the latest family-friendly developments, and we're going to have a focus on the new neonatal care leave and pay legislation, which is actually coming into force in April 2025, so very timely. And we're going to look at its impacts on the world of employment law. Maddie and I are actually members of our core equality, diversity, and inclusion specialist team, and we've spent quite a lot of time considering the new regs. We are then going to hand over to Cara, and Cara is also going to be doing a section on some very interesting recent case law, and she'll also be highlighting a few key legislative updates you should have on your radar too. So, just before we get started, as usual, just a few housekeeping points to cover. Please, can everyone just ensure you keep yourselves on mute during the webinar? If you do have any questions, then if you put them in the chat section and we'll pick them up at the end of the session. We might not have time to cover them today just because we've obviously just got an hour lunchtime slot, but we will follow up direct with anyone if we aren't able to come back to you today. Also, again, just need to highlight as usual, the session is being recorded and the recording will be shared with everyone after. We also have a few holding slides throughout the session, but as it's largely discussion based, there is no continuous slides. So just so you're aware, we won't have slides throughout, but there will be some holding ones. And I'll now hand you over to Maddie to get started.
Thanks, Fiona, and thanks for joining us, everyone, today. So yeah, I'm just, as Fiona said, I'm just going to start by outlining what the new neonatal care leave entitlements will look like, which are coming into force next month. So over the past couple of years, there's been a raft of changes across the family leave entitlements in the UK. So we've seen the introduction of carers leave, we've seen changes to how and when fathers are able to take paternity leave, and there's been strengthened protection for those returning from family leave where their role is facing redundancy. So this is one of the latest of these changes, and it's the introduction of the right to neonatal leave and pay. So a 2019 study found that 2/3 of fathers had to return to work whilst their child was receiving neonatal care, and that 36% of dads took sick leave in order to spend time with their baby on the neonatal ward. So as a result, the previous government announced in 2020 that it would bring forward legislation which provided statutory leave and pay entitlements for parents whose newborn required neonatal care. But now, 5 years later, the Neonatal Care Leave and Pay Act 2023 is finally entering into force, and it's expected that around 60,000 new parents will be eligible, with 34,000 parents taking up paid neonatal care leave each year. I know that Fiona will touch on this later on, but it goes without saying that that looking after a child who's requires neonatal care will be an extremely difficult time for new parents. And so this law seeks to ensure that employees are able to spend much needed time with their child whilst providing enhanced income security for eligible employees during this time. The new law is set out in draft regulations, which remain subject to parliamentary approval. But given the proximity to the law entering into force, we would expect, or at least we'd hope, that the regulations will largely be in final form. So now let's run through what the new law will look like in practice. So from 6th of April this year, parents will be entitled to a maximum of 12 weeks leave where their newborn requires neonatal care. So as we'll discuss, I think probably with the intention of allowing a degree of flexibility to how the leave will operate in practice, the way that the legislation is drafted does present certain complexities in relation to how employers will have to calculate and manage leave. But I think from the outset, it's important to note that whilst employers will have these statutory duties, you should be dealing with these situations compassionately and providing adequate support to employees during this time, probably more so here than with many other situations where an employee is taking leave. So the entitlement is the entitlement to leave, sorry, is a day one right. So that means that employees are not required to have worked for their employer for a certain amount of time before they're eligible. However, in contrast to this, employees are required to have 26 weeks continuous service before they're eligible for statutory neonatal pay, which I'll touch on slightly later. In order to qualify, the employee must be either the baby's parent, the baby's intended parent in an adoption or surrogacy situation, or partner to the baby's mother, who's unrelated to the mother and living with them in an enduring family relationship, um, with the expectation that they'll have responsibility for raising the child. So importantly here, both parents are able to take this leave, which goes back to the policy drivers behind the legislation. Now turning to the types of leave the types of care which leave must be taken in respect of. So this will be either any medical care received in hospital, and we've got quite a wide definition here as this encompasses any institution for receiving and treating ill people, or any maternity home, and includes clinics and outpatient departments maintained in connection with any such institution or home. Medical care received in any other place following discharge from hospital. The caveat to that is provided that the care is under the direction of a consultant, but it does include ongoing monitoring and visits from healthcare professionals arranged by that hospital. And then lastly, palliative or end of life care. So the neonatal care must have taken place or begun within the first 28 days of the child's life, and that clock starts running from the day after the baby is born. And the care must continue for a period of at least 7 continuous days. Therefore, in terms of statutory obligations and entitlements, this means that parents whose child requires hospital care after the first 28 days of the child's life will not have any statutory rights in neonatal care leave. So I think this is an example of where there's an opportunity for employers to provide more generous neonatal care leave or pay entitlements. For example, an employer could operate similar entitlements for employees whose newborn requires care, for example, in the first 3 months of the child's life. So let's look at the entitlements that employees will now have under the new law. So I've mentioned that they'll be able to take up to 12 weeks leave and pay under the new law. And the way that this is calculated is that eligible employees will be able to take 1 week's leave for each week that the baby receives neonatal care without interruption. And then this is set to that cap of 12 weeks. For these purposes, the week begins on the day after the care has started, and the leave can only be taken in 1 week blocks. So how it's intended to operate in practice is that employees will either be able to take the leave whilst the child is receiving the care, or they'll be able to bolt on their entitlement onto the end of any other family leave that they've taken. And this is because in practice, it's likely that an employee's baby whilst an employee's baby is in neonatal care, the employee may already be on some other form of family leave at that time, for example, maternity or paternity leave. So this way, it means that employees will be compensated for the time that they spent with their child in neonatal care. And it's because of this that the care leave can be taken within the first 6 to 8 weeks of the baby's life, or placement with the family and adoption cases. I'll come on to this shortly, but this is essentially the distinction between Tier 1 and Tier 2 leave. Lastly, it should be noted that neonatal care leave cannot be claimed twice in respect of twins or multiple births where the babies are receiving the care at the same time. So, for example, parents of twins who both require 8 weeks neonatal care, if they're receiving that at the same time, they would not be entitled to 16 weeks leave. It would just be the 8 weeks, and then plus that's capped at the 12 weeks. So now just look at how the law distinguishes the leave. So we've got 2 main categories of leave, Tier 1 and Tier 2. I'll quickly run through what this means, and then we can take a look at the notice requirements of each respective period. So the Tier 1 period applies to leave which is actually taken whilst the child receives neonatal care. The Tier 1 leave will come to an end when the child stops receiving care for a period of 7 continuous days. as Fiona and I were discussing, it's not entirely straightforward, but there can be more than one period of Tier 1 leave where a child stopped receiving neonatal care for 7 days, but then has to receive further care, and that further care is also received within the first 28 days of birth. So in practice, this is likely to be taken by fathers who've already exhausted paternity leave entitlements, or the mother's partner, as mothers are likely to already be on maternity leave whilst the baby is receiving care. So during the Tier 1 period, the leave cannot be taken during the first week that a child is in neonatal care. This is slightly confusing, but if we go back to the requirements, it's because the neonatal care leave can only be taken in respect of children who spend 7 continuous days in neonatal care. Again, slightly confusingly, that week starts from the day after the care has started. So it's not the most straightforward drafting, but it's probably better to think of the qualifying period as 7 nights rather than 7 days. And effectively, if you count the day that the neonatal care starts, the earliest day that the leave that can begin is day 9. There are softer requirements where an employee takes leave during the Tier 1 period. So here, notice is only required to be given before the employee is due to work on their first day of absence, unless it's not reasonably practical for them to give notice at that time. In those cases, it would then fall to when the notice could be reasonably given by the employee. Notice does not have to be in writing for Tier 1 neonatal care leave. However, it does if the employee wishes to receive neonatal care pay during in respect of this period. So now turning to Tier 2, and this is any other leave which is taken in respect of neonatal care. So essentially, it's any leave that's taken after the child has already received the care. As I touched on earlier, this is likely to be bolted onto the end of an employee's other family leave entitlement and means that they're compensated for the time spent with the child receiving care where they were already on, for example, maternity leave at the relevant time. It's important to note that this leave can only be taken in a single block. So where an employee wishes to take 1 week of statutory leave, the notice must be given no later than 15 days before the first day of neonatal care leave, and for 2 or more consecutive weeks of Tier 2 leave, the notice must be given 28 days in advance. And I'll just quickly run through the requirements, the notice requirements, and this is irrespective of whether an employee is taking leave in Tier 1 or Tier 2 leave. Before I do, I think it's important again to note that the legislation has built in the flexibility for employers and employees to mutually agree to waive the notice requirements, which again is something that you may wish to consider when you're implementing your own policies and procedures on neonatal care. So in all instances, the employees must tell the employer the date of the baby's birth or placement, the start and end date of the neonatal care, where the end date is known, and then where it's not known, as soon as they need to provide that information as soon as reasonably practicable. The date that they want the neonatal care leave to begin, how much leave they want to take, confirm that they're taking the leave to care for the child, and confirm that they are eligible. But again, as I've mentioned, it might be that this is a really difficult time well, obviously it's a very difficult time for parents, and you may wish to kind of soften those notice requirements in light of that. Finally, I'll just move on to the pay. So whilst leave is a day one right, employees will be required to have worked for their employer for 26 continuous weeks before they're eligible for neonatal care pay. So the pay entitlement mirrors that of the statutory paternity leave, and is also subject to a lower earnings limit, which is set to increase slightly, I think by £2 to £125 per week in April. So that's a quick run through of the legislation. I think I can appreciate it's quite confusing with the different periods that of leave and how you calculate that. But hopefully once it's enacted into law and you are more used to dealing with these kind of requests, these things will kind of iron themselves out. So yeah, I'll now pass over to Fiona, who will discuss how the leave will interact with other forms of family leave and discuss redundancy protections for those on neonatal leave.
Thanks, Maddie. And I'm sure everyone will agree that, it's a really positive step to introduce this type of leave. And what we should say is what Maddie has described as the statutory requirements are coming into force next month. However, it may be some employers at their discretion may decide to go beyond the statutory requirements, for example, offering full pay during neonatal care leave rather than the statutory amount. Um, and in reality, it may be that some employers have already offered this type of leave in the past, but it's not been labelled neonatal care leave. For example, there might have been certain situations in the past where employers have allowed an employee um, whose babies in neonatal care leave, probably normally the partner, because the mother would be on maternity leave anyway. But you maybe offered the partner some paid time off while the baby was receiving neonatal care. So it might be that even though this wasn't in place in the past, there have been circumstances where time up has been allowed off and it's been paid or unpaid. But I think it's good now to have the new regime in place. So the rules are quite complex, as Maddie's spoken through, and employers will need to be mindful of how the new rights interact with other types of family leave. Because, for example, neonatal care leave, it might overlap with different family rights depending on when it is taken and also by whom it is taken. So, a parent who's on maternity leave or shared parental leave or adoption leave is likely to add it on to the end of the longer period of leave, as Maddie had mentioned. Um, and you'll remember what Maddie said is that it's intended to operate in practice that employees will be able to bolt neonatal care leave onto the end of family leave they have taken. Then you've also got a parent who's maybe only entitled to a shorter period of family leave, and that will be predominantly somebody um, on paternity leave. And it's more likely that they will use the neonatal care leave for immediate time off whilst the baby is still receiving care. So you can see how it works in different ways depending on who is taking the leave. So coming on to considering other family leave rights, um, I'm sure most people on this call will be aware that another recent development in terms of family leave in recent years has been the increased protection in relation to redundancy. So, what we thought would be helpful is to remind you of the family leave redundancy protection changes that came into force last year and also explain the relevance of the new neonatal care rules to these. So, as you'll likely be aware, in a redundancy situation, there is an obligation to offer an employee on maternity leave, adoption leave, or shared parental leave a suitable alternative vacancy if available. They effectively take priority over other employees. So, employees who have notified their employer of their pregnancy or are on or have recently returned from a period of maternity leave, adoption leave, or shared parental leave, they have a preferential right to be offered any available suitable alternative vacancy. And before the 6th of April 2024, so a year ago, before that, this protection only applied during the leave. However, it was extended under the Protection from Redundancy Act 2023. And since then, for most cases, the relevant period of the protection for maternity leave is now an unbroken period starting with the date of notification of pregnancy and ending 18 months after the birth of the child. And there are also specific rules for when an employee suffers a miscarriage. For adoption leave, the redundancy protected period starts on the day of the employee's adoption leave starts and it ends 18 months 18 months from either the date the adoption placement starts or the date the child enters England, Scotland, or Wales if it's an overseas adoption. And then slightly different for shared parental leave. For shared parental leave, the position is variable depending on the length of time taken. So for shared parental leave, the redundancy protected period starts on the day a period of shared parental leave starts. And if the employee takes less than 6 weeks shared parental leave, the protected period ends on the last day of the block of shared parental leave. But if an employee takes 6 weeks or more continuous leave, the protection period ends 18 months from the date of the child's birth. So the 2024 new rules actually meant that a lot more people will be protected in terms of redundancy when they take family leave. So it was quite a big change. Um, and I think it is. worth flagging also in terms of parents with shared parental leave, there are different rules if it's discontinuous leave taken, and also if an employee on shared parental leave has already taken adoption leave or maternity leave, they will have redundancy. They will have the redundancy protected period for that specific type of leave as well. So you've got to kind of factor everything in and consider it, and it's not always straightforward to work out the timelines. And then to add to that, and this is one of the key reasons we wanted to just go over these rules again today and flag it to you, is that from next month, once the neonatal care rules are in force, if an employee takes a period of 6 continuous weeks of neonatal care leave or more, that employee will qualify for enhanced redundancy protection too. So you see that that is similar to how it operates for shared parental leave. Um, and that means that if an employee's role is redundant during neonatal care leave or for the period of 18 months from the date of the birth or placement for adoption, that employee is entitled to be offered a suitable alternative vacancy with their employer if one exists in a redundancy situation. So again, like the shared parental leave, it's this: well, if you've taken the 6 weeks continuous leave, then you also have that protection in terms of neonatal care. So employers need to make sure that they're holding clear records to be able to track protected periods for their employees. Because if they are missed and there's been a failure to offer a suitable alternative role in a redundancy situation, then there will be a breach of the regulations, and it leaves employers exposed to employment tribunal claims that they won't be able to successfully defend. Um, and I think it is really important to make clear that an employer can make an employee redundant during a protected period due to family leave. Is not a complete ban on that. The priority right is to any alternative roles if available. But in some circumstances, there will not be any alternative roles available. But it's just to flag that because I think sometimes people get confused on that. Um, so that's really important just to highlight that the neonatal care rules will be relevant to that extended redundancy protection period as well. Um, and what we're going to do, and we thought would be helpful, would be to look at an example. We've got a slide where we've got an example which covers both neonatal care leave being taken and also considerations about redundancy on it. So the slide that we've just shared, I'll just read it out, and then we'll just have a chat about how this situation works, and also if there'd been some variable different things going on, what impact that would have. So Emma informs her employer she's pregnant in May 2025. After her baby boy is born in autumn 2025, he immediately spends 9.5 weeks in neonatal care. Emma's partner takes 2 weeks statutory paternity leave immediately when the baby is born and then opts to take 7 weeks neonatal care leave. Emma's partner has worked in his role for 5 years, so he is due neonatal care leave pay too, because he qualifies for the pay. As Emma's partner takes a period in excess of 6 continuous weeks neonatal care leave, he also qualifies for enhanced redundancy protection too. So you can see just from reading that out, there's quite a lot of things for HR and ER and managers to be considering when dealing with these types of scenarios. And then if we move on to Emma, after Emma's maternity leave, she elects to take 8 weeks neonatal care leave. She adds a period of neonatal care leave on after her maternity leave ends, and that's Maddie pointed out that would be probably the common situation where you bolt it onto the end, because if you stop the maternity leave, then that would bring it to an end. So that's why you'd be taking the neonatal care leave after the maternity leave. And then Emma will already qualify to have the enhanced protected period in terms of the redundancy considerations due to her maternity leave. So in this example, neither parent opted to take the maximum neonatal care leave available, and that actually might be quite common, because it may be that in most situations, unless employer decides to, at their discretion, to pay enhanced pay, that you're only getting statutory neonatal care pay. And there might be situations where parents decide to opt to take some neonatal care leave and also take some holidays, because during the holidays they'll be getting full pay. So it won't always basically every situation will differ, and it would depend what the 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 parents decide to do. But I think we'll keep this slide up. I think it'd be interesting just to look at some variables, like what would have impacted this scenario if things had been different. So thinking back to what Maddie had explained earlier, and say in this example, the baby had required hospital care from when he was 40 days old, then the new provisions would not be applicable because the new statutory rights under the Neonatal Care Leave and Pay Act only apply where the child requires specialist neonatal care within 28 days of birth. So actually, if the care wasn't needed until 40 days, this would not apply. So I think it's just to flag that, in terms of the dates, it needs to be in the first 28 days of birth. Also, if Emma's partner had only taken 2 weeks neonatal care leave, he wouldn't have qualified for an enhanced redundancy protection period. He wouldn't that mean be covered for the 18 months protection period from the birth, and and if there was a redundancy situation in his work during that period, he wouldn't get a priority right to a suitable alternative role. So as we touched on earlier, you need to have the 6 weeks on neonatal care for the protection to apply. But that shows, somebody could take 5 weeks and somebody could take 6 weeks and both go back to the same workplace, and only one of them would have the protected period in relation to redundancy. So it shows what an impact that can have. So that's another variable just to consider. And then if it hadn't been just one baby boy, but two baby boys, and it had been twins born, and again, Maddie chatted about this earlier, um, if the twins had received treatment for the same period, then it would make no difference, as neonatal care leave cannot be claimed in respect of babies who are receiving care at the same time. But if one of the twins had maybe been in neonatal care for a week or two longer, then there would be an extended period of time. So I think that example just shows there's quite a lot to consider, and just touching on the three examples, if the situation had been slightly different, the impact that would have on the scenario. So to help you all out in terms of like managing this going forward, what we thought would be quite helpful to do is just collate some top tips in preparing for neonatal care rules, and also just a wider family leave considerations, particularly in a redundancy situation. So we're just going to run through now some top tips, and we'll also circulate a blog on this later as well. So don't feel you need to take them all down, but hopefully they'll be helpful more from a practical side as well. So firstly, the first thing we would say is that employers will need to have a policy regarding neonatal care leave. We have been asked by a number of clients, should that be a standalone policy, or should they be incorporating that into another family leave policy? I mean, I think from our perspective, either is fine. But as Maddie has shown, the rules are quite complex regarding like notifications, etc. So it might be easier to have a standalone policy. But the important thing is you get one ready for the rules coming in next month. Secondly, you should also be updating your employees of this new right to take neonatal care leave, and that also there's a new policy being published. And it's important that employees know it's available to them if they're required to use it, this new leave. So this may be via, yeah, you might update employees by sending a staff email, internal training session, updating on an intranet, or you might do all three. But the important thing is that it's clearly communicated. Um, Employers should try to ensure that it is as easy as possible for employees to request this type of leave. I mean, this will likely be a really stressful and difficult time in their lives, and it's important that managers are also aware of this right and trained how to handle such requests. Because by managers being fully informed of the right, then it should allow them to handle any requests more sensitively and promptly. And I think an employer would want to make it as easy as possible and be as accommodating as possible for an employee to take this type of leave at a really difficult time in their lives. So I think it's important that it's as easy as possible for them to take, and that managers are aware of this, and it can be dealt with sensitively and promptly. And a way of doing that is that we would recommend that you would have a template form, and that would hopefully assist when an employee is trying to make the request. And you'd have a form, just all the key information that you need, and the employee can then just complete that, and that should be quite a straightforward process. So I think having the policy but also a template form for requesting it. um, Other top tips that we were thinking about is, we think that it's important to be clear on your position from the outset if you're offering enhanced neonatal care leave pay. There's no requirement to do so, and it's just at an employer's discretion. But if you do already offer other types of family leave and enhanced pay, then you may want to do so for neonatal care leave too. What you don't want to do is you don't want to end up in a situation where some employees are being given enhanced pay by the employer and others aren't, because then you get into the danger that inferences can be drawn from that, and it can leave you exposed to allegations of unfair treatment. So I think you want a consistent approach, about what your approach is to the level of pay that will be paid. I think it also goes without saying that it's so important to manage these situations sensitively. It'll be a really difficult time for parents, and it's really important to display compassion and be empathetic. Um, as Maddie mentioned at the outset, employers should be dealing with these situations compassionately and providing to support to employees during this period. So, and it may be that some employers may opt to waive notice requirements, like, especially in the tier one period. But I think it's just really important that you want to be seen to be supporting your employees at a really difficult time for them. Um, Another thing to consider, which is maybe not always as obvious, is also the data protection considerations. Is you might be holding information regarding the baby's health, and also employees might not want other employees to know why they're taking leave, and you just got to be careful around this. So I think it's just something to keep on your radar and ensure you comply with all your data regulations. And on the practical side, another thing to be thinking about is payroll systems. You need to ensure that the payroll systems are able to process any neonatal care leave payments accurately, and especially if they're going in, if you've been on maybe maternity leave and then it's changing to neonatal care, or paternity and neonatal care leave, just make sure that the payroll systems are processing it all correctly, because you really don't want to be in a situation where the parents haven't been paid correctly due to an error. I mean, all these circumstances will vary, but you could be in a situation where parents could be relying on that money to pay for accommodation because maybe the hospital is far from their home, and you just want to ensure everything runs smoothly in terms of payment. So I think just making sure payroll systems are ready for it. Also, in terms of the redundancy protected period that we touched on, and I discussed in quite a lot of detail, you need to be ensure you're tracking redundancy protected periods. Um, in relation to all types of family leave when it applies, because you don't want to forget about people who are within that protected period. So that's really important. And you need to be considering who has additional protection in any redundancy scenario. And I think internally you want a clear way to be able to track that. I'm sure you're probably a lot of you are doing that already, but it's just something to make sure you're thinking about, and especially if you are in an unfortunate scenario where there is a redundancy um, looking likely, a redundancy situation looking likely, to have that on your radar straight away. Who is still within their extended protection period, and also, in terms of other top tips and redundancy situations, you need to be considering suitable alternative roles. So it's one thing knowing these people opt to be offered a suitable alternative role when it exists, but you also need to be considering, what are there any suitable alternative roles? With the changes that this year with neonatal care, and then last year with the period being extended um, for protection and redundancy, more employees will qualify for this priority right to a suitable alternative role, and you need to ensure this is it's been considered. Are there suitable alternative roles, and apply your mind to that, and ensure they're offered if available. And you don't forget about it. It's one thing knowing that's right's there, but then you need to also put your mind to it and think, is that role suitable or not? And don't forget about that. And the fact that with the changes in the law, more people will be protected. You might actually end up in situations where you've got various people protected and there's only one suitable alternative role, and they've all got the same right. And Cara and I were actually just chatting about this before the call. In that situation, how do you differentiate between the people? And it might be for those people then who have the protection, but there's more than one of them and there's only one suitable alternative role that applies to them all. Then it might be then you need to do a scoring specifically to them. But that's probably more likely to come up now than in the past because the protection is wider. So, um, just another thing to be considering. But it's probably, would always say, it's probably sensible to take some legal advice in those type of situations, because they are quite challenging and not straightforward. So hopefully those practical tips are useful. And before we get on to the case law updates, we just wanted to touch on some more family um, leave changes that might be coming in the future. And also, we couldn't really go through a LOLAB update without inevitably bringing in the Employment Rights Bill, which I'm sure is a hot topic for most of you on the call, and it's certainly a hot topic for the employment team here at Barnes Paul, because there are also some family leave changes expected in the near future due to the Employment Rights Bill. So the Employment Rights Bill will remove the current qualifying period of employment for both paternity leave and parental leave, making them available from the start of the employment. So the new bill will actually also permit employees to take paternity leave after a period of shared parental leave, which is currently not permitted. So this isn't in yet, and obviously there's still going to be some time before these rights come in, before the Employment Rights Bill is passed and everything comes into legislation. But it's just to flag there will be further changes, which means there'll be further updates in due course that you'll need to do to your family leave policies. I mean, one thing that we should say that, of course, like currently some employers, maybe some of you on the call, at your discretion, may have company policies in relation to family leave that already allow parental leave and paternity leave as a day one right. But what we're flagging is that in the future, this will become a statutory position. So just to have on your radar, nothing needed to be done on it yet, but just to flag when we're speaking about family leave policies that there is more changes to come, and that no further updates will needed to be made. So that's really what we wanted to cover in terms of neonatal care and the wider family leave considerations. And we're now going to pass over to Cara, and Cara is going to look at a few interesting cases that have recently we've received judgments on, and then she's just got a few other things to put on your radar in terms of updates. So I'll pass you over to Cara now.
Thanks, Fiona. I'm sure you will all find that super helpful. But yeah, as Fiona mentioned, I'm just going to turn now to some practical tips that can be learned from some recent interesting cases that have been published. And after that, if I've got time, I'll also provide sort of a brief overview of some of other imminent legislative updates that are on the horizon. So the first practical tip comes from the case of Easton, the Secretary of State for the Home Department. So in this case, the Employment Appeal Tribunal considered whether an employee's dismissal for failing to disclose a previous gross misconduct dismissal in a previous role in his application for a new role was fair. So in this case, the claimant had essentially applied for a job with the respondent, who was, as I say, the Secretary of the Home Office in 2019. And in the application form for that role, there was an employment history section with a sort of free text box for information to be entered by the applicant. Now, the form didn't explicitly require applicants to provide the exact dates of employment for any previous roles. So the claimant in this case completed this section using years only, meaning that a gap of sort of around 3 months employment after he was dismissed from his previous role for gross misconduct was not brought to the respondent's attention. As I say, the dismissal was from a previous role, but was actually from a previous role where he had worked in the Home Office, who is the respondent in this case. So the claimant had ticked a box on the application form which stated the following: I understand my application may be rejected, or I may be subject to disciplinary action if I've given false information or withheld relevant details. Now, after the claimant was successful and was appointed to the role, and after the claimant had started working for the respondent, this respondent subsequently found out about the claimant's previous dismissal and actually commenced disciplinary proceedings concerning the allegations that he had failed to disclose the material, or what they allege was material details in the application form, i.e. that he had failed to mention that he had previously been dismissed by reason of gross misconduct. So during the disciplinary proceedings, when the claimant was questioned about why he did not include the information on the application form about his earlier dismissal, and I guess the gap in his employment history, the claimant alleged that he did not consider it to be relevant information. Now, the employer dismissed the claimant for gross misconduct for failing to disclose these details regarding his earlier dismissal, and on the basis really that he was trying to conceal a period of unemployment following that dismissal. So the claimant subsequently raised an employment tribunal claim for unfair dismissal. And the employment tribunal at first instance found that the disciplinary investigation, the disciplinary and the appeal process that followed that, and the sort of resulting decisions to dismiss all fell within the band of reasonable responses, and as such that the dismissal was fair. The claimant then appealed that decision to the Employment Appeal Tribunal on the basis that the judge's failure to recognise the ambiguous nature of the application form was a legal error. And his position essentially was that the respondent had not been specific enough about what information it was that they were seeking by way of the form. And additionally, the claimant also argued that there is no general duty of disclosure on any candidate or applicant in a job context, and that in the circumstances he completed the application form to the best of his ability and knowledge, and that he hadn't willfully withheld any information from the respondent. His sort of last line of argument as well was that the respondent had knowledge of his previous dismissal because it was the respondent that had dismissed him previously. So it was different sections of the Home Office that he had applied to. However, it was not the same branch or agency of that. So the Employment Appeal Tribunal held that whilst a different employer may have reached a different view in the circumstances, it couldn't interfere with the previous decision that the Employment Tribunal had made. The Employment Tribunal's role in the first instance was to scrutinise whether the process and the decisions that had been made by the respondent were within the band of reasonable responses. And the Employment Appeal Tribunal found that the Employment Tribunal conducted the correct exercise and was entitled to find on the facts of the case that the way that the claimant had presented the information on the application was dishonest. The Employment Tribunal found that when considering the claimant's evidence, he understood that any dismissals and periods of unemployment would be relevant material information that the respondent would have required to be aware of as part of an application process. And interestingly, on the sort of last point I mentioned of the claimant's argument, the Employment Tribunal noted that the Home Office is a very large organisation, as I'm sure we're all aware, and it couldn't have possibly been expected to have sort of collective memory of all HR records and have access to that. Interestingly, in the judgment, the judge commented that he didn't think there was anything ambiguous about the application form, and they thought it was quite straightforward. So, what sort of lessons can we learn from this case? It's really a good reminder for employers to ensure that application forms are clear and specific about exactly what information the applicant is expected to provide. I think in this case, it could have been open to the tribunal to establish that the application form wasn't clear and concise. So I think it's a very good lesson and top tip for moving forward that we're making sure that applications forms are as precise as possible. This will help to avoid any similar situations or arguments being brought by any applicants or employees. Another thing that would probably be a good top tip is to ask applicants to confirm that the information they have provided is complete and accurate, and acknowledge that they may be dismissed if the contrary is found. And that could just be done by sort of a short sort of section at the bottom, which employees or applicants are required to sign. So turning on to the next case that we have is the case of Islam Right versus the Arts Council England. So in this case, the Employment Tribunal determined, or were required to determine, whether an employee was constructively dismissed for criticising colleagues with gender critical views. So the claimant in this case was a relationship and diversity manager, and the respondents essentially awarded a grant to a programme, which in turn provided an award to the Lesbian, Gay and Bisexual Alliance, so otherwise known as the LGBA. And whilst the respondent in this case did not directly provide an award to LGBA, as I say, it was done via a programme, it received criticism for the award, as some staff viewed the LGBA as being transphobic or anti-trans. So in response to the respondent making this grant and subsequent sort of management discussions and communications about the grant, a working group grievance was circulated via email to staff, and this email included a link to something called an Allies support sheet, which was going to be submitted alongside the grievance. So the sheet was open to all staff to view and add comments on, so that they could join the grievance. And the claimant in this case posted a comment in this spreadsheet that was circulated, and in her comments she compared comments made by those who hold the belief that sex is binary, i.e. gender critical beliefs. She compared those to racist statements. And following the comments that were made, the claimant was invited to a disciplinary investigation meeting, which her line manager was none the wiser of. And she was provided with 2 anonymous impact statements regarding the comments made that she had made in the spreadsheet. And whilst neither expressly quoted the claimant's comments, both of these impact statements referred to the adverse impact on those individuals of having their views on gender being compared to racism. During the investigation process, the claimant had expressed that she was anxious and frightened about the process to HR, And she also raised concerns under the respondent's dignity at work policy, both of which were treated rather dismissively by the HR team. And the HR representative who was specifically dealing with this matter also accused the claimant of refusing to participate in the disciplinary process unless it was on her terms, and warned her that sort of any willful obstruction of the process may be considered misconduct. And the claimant continued to raise concerns about this HR representative's continued involvement, and statements that she had provided to be read during the investigation meeting were not properly considered in advance of that meeting. So there was a whole host of sort of apparent failings with how the claimant had been treated as part of the process. And at the investigation meeting, the claimant's position was that she had understood the spreadsheet to be directed at allies and supporters of the working group, and she had stated that the comment that she had made and inserted onto the spreadsheet reflected on her personal perspective, having experienced racism, but that it was never ever her intention to vilify anyone or cause any sort of hurt. And she reiterated this position in writing following the investigation meeting. The claimant was then subsequently invited to a disciplinary hearing and resigned in response to the way that she had been treating, stating that all attempts to get a fair hearing had been ignored and that she had been threatened and undermined throughout the whole investigation process. She then subsequently raised a claim for constructive unfair dismissal and victimisation. The victimisation claim was dismissed, but the constructive unfair dismissal claim was upheld. Now, as some of you may know, to succeed in a claim for constructive dismissal, the employer's actions or conduct must have amounted to a repudiatory breach of the employment contract, which is entitled the employee to resign. Now, there is a applied right into every contract of employment, a duty of mutual trust and confidence. And each party to the contract must not, without reasonable and proper cause, conduct itself in a manner which is likely to damage that relationship of trust and confidence. So if an employment tribunal finds that a party has acted in such a manner that will amount to a repudiatory breach, and an employee can also resign in response to a series of breaches of contract or a course of conduct by their employer, which, when taken cumulatively, amounts to a breach of the implied term of trust and confidence. So in this case, the employment tribunal accepted that the respondent had grounds for being concerned about the claimant's comments, but ultimately found that the way in which the respondent had handled the process breached the implied term of trust and confidence. And they had held that the HR representative approached the case and the matter from an organisational risk perspective, aimed primarily to avoid employment tribunal claim from other employees, which ultimately caused them to lose sight of whether there was any grounds for disciplinary action against the claimant. without undermining the upset caused by the claimant's comments, the Employment Tribunal also found that in the circumstances, the first step under the respondent's disciplinary policy should have been for the line manager to discuss the concerns with the claimant. But of course, the line manager was none the wiser of any of this until the employee was invited to an investigation meeting. So that being the case, the Employment Tribunal found that the invite coming out of the blue and without the knowledge of the claimant's line manager, the HR representative dismissing the claimant's genuine anxieties over the whole process, failing to pause and properly consider the dignity at work complaint, and accusing the claimant themselves of being obstructive, which the Employment Tribunal found was not the case, and threatening the claimant with further disciplinary action. They found that all of these matters breached the trust and confidence of the claimant. And the Employment Tribunal also noted that the HR representative accusing the claimant of being obstructive and threatening disciplinary action was conduct sufficient in and of itself to amount to a breach of the implied term. So notwithstanding all the other points as well. So this case sort of provides two helpful reminders for employers. Firstly, it's crucial that staff are trained on the law under the Equality Act and what may amount to a protected belief. It was clear sort of in this case that the claimant misunderstood protections under the Equality Act and did not fully understand what may amount to a protected belief. But having an up-to-date policy which references the correct terms is also really important. But also, secondly, where competing beliefs are at play, it's very easy for an employer to be concerned about reputational risk and have a knee-jerk reaction. And the Employment Tribunal was very critical of the respondent's heavy-handed approach to the process in this case. So it's important when dealing with sort of gender-critical cases or competing belief cases that employers take legal advice and ensure that any matter is handled in a fair way. And this is sort of an area that we're seeing an increase of definitely over the past sort of year or so. There's a lot of cases sort of cropping up in the sort of competing beliefs area, and it's something that we're regularly advising clients on. So I would just encourage people to get in touch and get advice at an early stage on these matters. So the third and final case that I've got, I'll just touch upon really, really quickly. In this case, the Employment Tribunal considered whether the 2-year backstop on unlawful deductions claims is unlawful. So the sort of crux of this case was sort of primarily concerned around worker status and whether taxi drivers were worker or self-employed, and therefore whether they could bring claims for non-payment of holiday pay and national minimum wage. So the Employment Tribunal found that drivers who used the respondents' branded vehicles were engaged as workers whenever they made themselves available for work by logging into an app that the respondent had. But there was a distinction between those individuals and partner drivers who use their own vehicles or vehicles leased from other third parties, because they were only deemed as being workers once they accepted a journey request via the app and for the duration of that job. So the distinction is that partner drivers were allowed to offer their services on other apps at the same time as being logged onto the respondents platform, but the non-partner drivers were not. But as I say, the most important point of this case was the view that the Employment Tribunal reached on how far back any holiday pay claims for unlawful deductions of wages can go. So some of you may be aware that in 2015 regulations were introduced which essentially amended the deductions provisions that already existed in the Employment Rights Act by introducing this 2-year backstop on claims for unlawful deductions from wages. And the primary reason for introducing these regulations was to try to limit the impact on employers in respect of backdated holiday pay claims. But in this case, the Employment Tribunal determined that the driver's claims for unpaid wages for holiday pay should not be limited by the 2-year backstop. So this was quite controversial, and the Employment Tribunal's view was that the regulations went beyond legal authority, based and stated that based on a review of the relevant law, the backstop should only have been introduced via an act of Parliament, not simply via regulations, as they were, and as such that they were unlawful. So regulations are a form of secondary legislation and requires a lot less parliamentary scrutiny than introducing an act of Parliament. This judgment obviously is only a first instance decision, so it's not binding at present on other employment tribunals. And the judge did acknowledge that his conclusions about the 2-year backstop may be challenged and may well be wrong. And we have seen that an appeal has been lodged in this case, but it's something just to highlight to you all. It's important for employers just to be aware of this judgment, as it could be upheld on appeal, meaning that claims for holiday pay, national minimum wage, and sort of any other claims under the deductions from wages regime could go further back than the 2 years.
Yeah. I think it's a good one to have on our radar, isn't it, Karen? We'll definitely keep everyone updated in terms of the appeal. I'm just really mindful of time because I know it's 13:34 and probably people have calls to go on to now. So I think now we've wrapped up the 3 cases, we probably should let you all go and have your lunch if you've not already had it. But if there was any, I think there's been a couple of points put in the chat. Karen, myself and Maddie will pick them up and we'll just drop you an email in response to them. So if you have put something in the chat, don't worry, we will get back to you. But I think we'll let you go, have your lunch, and if there is anything specific, follow up that you want to get in touch with any of us about, then we're always keen to hear from you, and just feel free to drop us an email and we'll be sure to get back to you.